5-minute recess. Isn't this fun?
Lisi, I have a question because I don't know all the players. Who's our representative? Is that Travis DaCosta?
Oh, I'm very sorry. Yes, I'm sorry. That's Travis DaCosta. I forgot to introduce him.
Okay,
He's
I've never met him. Okay.
No, neither is anybody else.
Okay. I'm looking for our attorney.
Mike Marcello is sitting with the town council tonight that has a meeting simultaneously with ours.
Okay.
Sorry, Travis. Forgive me for being
No,
so.
it's all good.
You're all set. Thank you.
Okay. Mr. Pagliardi, why don't you
Thank
take
you.
it away?
This is a major land development project, 51 condominiums on Sousa Road and Main Road that was approved in 2008. Due to the state tolling statutes and several previous extensions through the planning board, the final recorded plan has not been recorded. The one outstanding matter was that DEM, we're waiting on the RIPD's permit. The RIPD's permit has been sought for well over a year now, and the delay became, once the engineers got into it, they noticed that water was going across Main Road down on the other side, down towards the hill into a depression. Based on the fact of the water fugitive escaping from the parcel, DEM required that redesign of drainage to keep the water on our parcel. That took time. Mr. Gillis, the owner of the property, on March 26th, applied for an extension of time clock, asking for an additional 6-month period. The planning board had a lengthy discussion, well over an hour, on many issues that were beyond the scope of the time clock. It seems as though several of the planning board members do not like the project, say it's not consistent with the current comprehensive plan, even though it was approved under the then comprehensive plan. If you look at the planning board decision, it's devoid of any rationale, any evidence that was on the record. The only thing referenced was member Hardy's commentary. There were no finding of facts. There was no rationale that would allow the board to deny the appeal. We filed the request, excuse me. We filed this appeal on procedural grounds pursuant to your regulations and state law. We feel as though that the decision that was granted was first defective on its face because there were no findings of fact. It seems as though the majority of the discussion had to deal with matters beyond an extension, and it was like we were representing the merits of the underlying approvals that were not at issue that evening. One of the most interesting procedural issues was that, as I stated, Mr. Gillis made this application on March 26th, well in advance of his June 30th filing the current extension time clock. Due to COVID, the planning board canceled its April meeting, its May meeting, and heard the appeal on June 4th. That becomes a very important matter from a procedural point of view. The town of Tiverton is still under an executive order by the town council such that we're not having this meeting in person because the town was directed to change the way it does business. Well, if we take that same logic and analogy, in June of 2019, Mr. Gillis was afforded a 12-month extension. That was effectively 2 or 3 months reduced because of COVID. Had he gotten his extension on the April agenda and had he timely received his RIPD's permit from DEM, who obviously was slowed down by COVID, he would have had time to react to what then transpired. And what then transpired is that the testimony that Mr. Gillis offered to the planning board was that it was imminent. RIPD's is coming. It should be here any day. And the planning board on June 4th said denied. Well, the planning board decision was rendered, I believe it was recorded on June 16th or June 17th. And on June 16th, the RIPD's permit was received by Mr. Gillis, as he had said it was imminent. Well, the administrative officer then said, well, based on your approval, you now have to go back to zoning because the additional zoning permission or approval had cited if there were any changes to the project that it had to go back to zoning. In addition, we now need an administrative subdivision. What happened was there's two parcels of land. One of them was to be commercial, one was to be the residential development. Now DEM is requiring that the commercial parcel become a drainage basin in its entirety. So we have to do an administrative subdivision. The planning board's taken the position that that is a significant change to the project and they want us to go back to zoning. Well, we weren't notified of that until June 19th by the town administrative officer, leaving us 11 days to apply to zoning. Obviously, we can't do that with a 21-day zoning notice appeal. I need approximately 6 to 8 weeks to make any application to zoning. So our approval has been frustrated by COVID because had we had meetings in April and May, those matters may have come to light. Had DEM been working, period, I guess is the best way of saying it, they might have gotten our approval sooner and we would have had time to make these applications. Now we're denied. We stand ready with our RIPD's permit, but these two subsequent conditions have been triggered that we need approximately 2 to 3 months additional time to go through. The planning board is troubled by development on Sousa Road. That necessitated the 2018 amendments to the comprehensive plan. There's a lot of development pressure on Sousa Road. Well, Mr. Gillis testified that he was second in the queue many years ago, and these problems were subsequent to his project. And the commentary of several planning board members was that they want him to go back to square one and start over again. That's hundreds of thousands of dollars in engineering and fees. It is years in time, but more importantly, it's to no avail because they know under the current regulations, the project would not be approved. So this is a de facto way of killing the underlying project. So we look at the procedural issues that occurred and we say, the only testimony given was Mr. Gillis. The planning board didn't base their decision on that testimony. They based it on commentary that was extraneous to the request by the planning board members themselves. Secondly, COVID greatly affected this development, procedural matters here because it frustrated DEM and the board did not timely give us a hearing. Now, we acknowledge and accept the delay had they granted the extension, but in the month of June to say your time is up and we're not going to extend the clock is not consistent with either the governor's executive orders nor the Tiverton Town Council's executive order saying work with people, treat business properly. So lastly, it comes down to procedurally, we have an issue with a timeline. How on June 19th do we find out about these subsequent conditions that we cannot possibly do in 11 days? So the record that you have before you has many exhibits, and it explains what I've just summarized to you, that there was prejudicial procedural error committed by the planning board for 3 different reasons, and that we feel, particularly in this time of COVID, that the board should have made an allowance for that time that was lost, because Mr. Gillis did not have a 12-month time clock. He really only had a 9-month time clock. And we're seeking, and we asked this board to overturn a decision that had no basis or rationale to it. It truly was based on extraneous beliefs by the planning board that went beyond the scope of their application for a time clock. So we're asking this evening that you grant an additional 6 months from today, because we've lost the month of July and early August today. So we would ask that this board respectfully grant the 6-month extension based on procedural error.
I have a couple of questions.
Sure.
Sometimes in your papers, you refer to a preliminary plan, and sometimes you refer to it as the final plan.
Everything was
Which
final.
one is it?
It's final. The only thing left to do on this project is record. This has passed every hurdle: master plan, preliminary, final. It just needs to be on record. And you can't go on record until you have all state approvals in hand. And it has been yeoman's work to get DEM to pass the drainage for the Ripties permit. It's been years.
Well, if you got the permit on June 16th, right?
The Ripties permit, correct.
And you still had time to record after that? You had 2 weeks to record after that?
No, because what happened was the Ripties permit causes a redesign, and the original zoning approval stated 2 uses, the commercial parcel and the residential. And now there is no longer commercial. So the planner, the town the administrative officer, sent us a letter stating that we had to go back to planning for an administrative subdivision, because you just can't have a drainage basin on its own parcel. So they want us to drop that commercial lot, 1.5 acres, back into the main parcel. So that requires planning board administrative subdivision. And additionally, they want us to come back to you sitting as the zoning board, so that you can see the change that the state is requiring us to make to your original approval, which was for a commercial parcel. So I've got 2 things I need to do that I could not possibly do from June 19th to June 30th, which is file with the zoning board for a special use permit and do the administrative subdivision through the planning board. Both of those are going to take 1 to 2 months at a minimum. And depending if I have to do one before the other, I'm looking at least 3 or 4 months.
George, did you have a question?
Yeah, just a quick one, clarification. You said that's the last 3 months with this epidemic, that's the problem. Didn't you, I understand that you applied a year ago for DEM and neither one has took that long?
Yes, George, what's
So
happened?
it's not, one second, just let me, so it's not the planning board or the zoning board or the agenda or none of that. You were waiting for a permit from DEM before we even could talk.
Correct.
And it took until June 16th to come in.
That is correct.
No one else could be blamed.
Well, it was.
Just, I'm asking for the time clock. No one else could be blamed. June 16 is when you got your DEM permit before you came in front of anybody.
That is correct.
Thank you.
June 16th, we received the Ripties permit that put additional conditions that we have to go through the regulatory process between zoning and planning. That permit was applied for well over a year ago.
Okay.
Anyone else have any questions? I have another one. Now, should we decide that this was, should we grant your appeal? What happens next? You have to go back to have further hearings at the planning board?
We have to go back to the planning board for the administrative subdivision to remove the second parcel. And then we have to come back to the zoning board on the special use permit to give you notice that DEM changed the commercial parcel. So yes, there's 2 more procedural hearings that are required.
Okay. Anyone else have any questions? Any members of the board?
I have one question. So the commercial parcel in totality will be a drainage basin. There won't be residential on there. It'll just be a drainage basin.
That is correct.
Okay.
Anyone else? Any member of the public want to ask any questions?
Yes, I'm Stu Hardy, the vice chair of the planning board, and my name has been invoked already. I'd like to ask, how many times has the planning board granted an extension of vesting for this particular project since 2008, running through 2019? Does Mr. Pagliarini know how many times we have granted an extension of vesting?
Madam Chair, I can answer that if you wish.
Sure.
I believe we've requested 4 short-term extensions. One was for 4 months, one was for 6 months. I believe one was for a year. But I don't want to get into any type of argument here, but this is the Board of Appeals, and I think it's inappropriate that a planning board member representing themselves as the vice chair participates in an appeal of their decision. I just want to put that on the record.
So noted.
Thank you.
Madam Chair, may I ask another question?
Yep.
The issue of the DEM permit, the permit in question is the Rhode Island Pollution Discharge Elimination System permit. Do you know when does anybody representing the applicant know when the new regulations for the RIPDES permit were promulgated by RIDEM? Was this just a very recent development causing you to completely reconfigure your application, or is this a much older situation? I'm talking about the RIPDES permit regulations, which are also connected to the stormwater manual, the current stormwater manual of the used by DEM. Can you tell me when that was?
Madam Chair, do you want me to answer that?
If you know the answer to it.
It's my understanding.
I frankly don't think it's relevant to the very narrow legal issue, but
I believe that the stormwater manual was updated in the year 2015. That's not what caused the issue. Is when they were conforming to the regulations of 2015, it was noted that there was fugitive water on the property, and that caused the complete redesign of the drainage. It had nothing to do with the regulations themselves. It was neither DOT or DEM were aware that the water was discharging off the other side of Main Road. So that's what caused the redesign.
So I have a third question, and perhaps legal counsel could respond to this one. Does the planning board have legal standing under the Rhode Island Land Development and Subdivision Review Enabling Act to deny an extension of vesting after a reasonable amount of time has lapsed?
It would need to be a finding that there was no good cause.
I don't understand your answer.
To grant the extension, you'd have to find that there was good cause to grant the extension. To deny it, you'd have to find that there was no good cause.
So that goes to my fourth and final question. Are you telling us, there are several planning board members here present, that when we extend or deny the extension of the vesting period for a project that has been approved at final plan stage but never actually recorded, that we need legally, that we need to make findings of fact?
So Stu, I don't mean any disrespect. I want to make sure that this hearing is specifically for the appellants and their particular legal issue here. I think that you and I, that's not relevant right now.
The very good attorney for the developer has raised the issue of our failure to make findings of fact. So I think that's a relevant issue that I can respond to because it's already been made and he was not ruled out of order by Madam Chairman. We have never, in my 10 years, and I've been chairman of the planning board, we have had many different legal counsels. None of them have ever advised us to make findings of fact when either approving or denying an extension of vesting. So this is all new to me.
John, perhaps you want to just...
I think this is not the time to be debating what...
Actually, Madam Chair,
the issue before us is extremely narrow. And I don't think we need, it's improper for us to get into the merits of the development or the project at this point.
But we're being challenged not on the merits of the project. We're being challenged on procedure that planning board followed during our deliberations on this matter. So we're being challenged procedurally, not in terms of the substance of the project. I have said nothing about the substance of the project in my comments so far tonight. I've simply talked about the issues that Mr. Pagliarini himself has raised.
But I think the appellants, here have the ability to an independent review, and I feel that we're subjecting them to two boards of review right now. And so if we want to talk hypotheticals outside of this right now, we can, but let's just allow them to present their case before the zoning board of review.
Madam Chair, if I may, just to bring closure to the line of questioning, I think that the vice chair raises a point historically, but there's an intervening factor, which is on November 5th of 2019, the planning board amended their subdivision regulations to require good cause extensions on final plan approvals. They may not have had more than one or two of these since those amendments. And what I believe that language now requires findings of fact, and I'll rest on that.
Anyone else have any questions? Seeing none, are we prepared to close the hearing and go into our deliberations? So we're doing that. It's a very limited scope here. We're not here to substitute our judgment for the planning board, but we're really looking at to see if this was an abuse of discretion. And what are your feelings on it? Dave?
This is obviously a very complicated issue. At this point, there have been 4 extensions that have been granted by the planning board. So obviously the planning board felt that these were important issues that needed to be addressed in the final plan. Now we've come to another hurdle that's been complicated not only by the DEM and lack of our ability to control the DEM, but also by COVID-19. And it seems to me that if we've gone this far and we've addressed all of these, we've continued to address all of these issues addressed in the 4 extensions, that they ought to listen to the last extension. They ought to get all the details and finish the project. That's just my feeling. I don't know what others think, but.
George?
I disagree with David. They've heard the fourth previous time for extension. They heard it. We were not there. They felt comfortable with giving an extension. This one has nothing to do with them. They heard their presentation. They disagreed with it. That's their job. They reviewed the whole proposal. They've looked at it a lot more than we have, a lot more than we understand it for the last 20 minutes. That's not their fault that they had a problem with DM and changes and refugee water. And according to John Pellegrini, all of a sudden they went quacky and they didn't discuss the right stuff. I disagree. They're all professional. They've done it for years. They gave them plenty of opportunity in the past. They don't like this one. Sorry.
Wendy? How do you feel on this?
Hold on, I had to unmute.
Sorry.
Don't be. I don't want us to make this issue more complicated than it is. It shouldn't be about any of the facts that went before the planning board. It should really just be about whether the planning board was correct in denying the last request for an extension. And I think because that could just be a legal question, I would love for our zoning board counsel to weigh in on just that question.
So what we're doing is reviewing whether or not the planning board was correct in, first of all, they didn't in particularity find that there was no good cause for not granting it. But what we're looking at is whether or not there was good cause to grant an extension, or if there was not good cause to support the planning board's decision to not grant it. Does that make sense?
It does.
John, Mike, do you agree?
I do.
Okay, so
You can't talk anymore. He
so
shut
that's it.
up.
It's really simple. It's really simple. I don't want to inject my feelings, of course, but that's the standard.
Well, it seems to me, and this isn't an easy issue. I mean, because you want to go through all of the things, all of the history of it, but that's really not our job at this point. Ours is simply to say whether the planning board was in error not to give them a final extension, given the COVID crisis, given the delay from DEM. And I don't think that, I think they should have granted the extension. And that's my feeling. Now, I realize it's going to go back to the planning board for additional review. And then it's going to come in front of us. So this is not the final sign of the cross over this project. I mean, they still have hurdles to jump through. And I'm sorry.
Sorry, go ahead. I apologize. Thought you were done.
No, I mean, my feeling is that, this isn't, the end of the road.
Sorry about that,
guys. Jay, where are you, Jay?
Wendy had her hand up.
Oh, Wendy, I'm sorry, I didn't see you.
When we're answering this question, is it important for us to just give a yes or no, whether the planning board was right or wrong, or do we need to give reasons why? For example, I read somewhere that back in 2007, the petitioners were made aware that if there were going to be any changes made to the original plan, they would need to seek zoning board approval. So on one hand, it shouldn't come as a shock that they need to seek zoning board approval. But on the other hand, because like Lisi said, because of COVID, things definitely have gotten messed up. So are we going to need to be so specific as to state why we either agree or disagree with the planning board, or just that we do or that we don't?
I think you should look at the totality of what has occurred. You can look at the history of, I know the planning board did say that one of the main reasons that they did not give the extension is because of the amount of other extensions. While I think that's something that they thought about and they weren't completely wrong in thinking about, I don't know that it's your decision to find if solely looking at the amount of other extensions is enough to say that there's good cause to not give another one. And so that's where you are coming in to say, I think that there was good cause or there wasn't. And you can look at the history and you can look at the other extensions if that's something that you want to do. And to answer your question specifically, yeah, you can definitely give reason. Absolutely.
Thanks.
Jennifer, do you have, Jay?
Yeah, I just want to say that I agree with you, Lise. I think that, DEM taking as long as they have has caused this whole issue to become a problem. So I think they should be granted an extension.
Joel, would you like to weigh in? I mean, you and Jennifer can certainly express your opinion, but you're not allowed to vote.
Yeah, no, I'm happy to weigh in. I agree. I think that we should grant the extension, just given the conditions that we're dealing with now. Maybe if this is a different year, maybe we'd feel differently, but it's been a crazy year and we have had a lot of delays, and I can't see a good reason why we wouldn't allow them. We're really, as far as I'm concerned, it was sort of out of their hands as far as why they were delayed. I think we should give them the extension personally.
I completely agree. I mean, there's been so much that has happened this year. And on top of that, they've had that permit into DEM for over 12 months. I mean, it's not like they put it in last minute, it's been in their hands for quite some time. So I completely agree with you, Lisi.
Okay. I'd like to make the motion that we find that the planning board did abuse its discretion by not granting this extension for a 6-month period of time as they requested, given the fact that DEM was so delayed in processing their application, and the planning board wasn't sitting for 3 months because of COVID. I think that they deprived the petitioner of the ability to complete the project, and this simply sends it back to the planning board for further review and for review by us. I think it's the most expeditious way of handling it, to avoid litigation about a very narrow issue. And so I would vote to grant the appeal.
Seconded.
David Collins seconded. All those in favor?
Let's do a roll call. Let's do a specific roll call.
Okay. Voting in favor of granting the appeal, David Collins, Lisa Gescheit, Wendy, Taylor Humphrey, and Jay Jackson. All those opposed? George Alzabak. So with a 4-1, what happens?
The motion passes.
You ask.
Does?
Yeah,
okay.
Yes.
Okay. So you're all set. The appeal is granted and the matter is remanded to the planning board.
With a 6-month extension?
Yes.
Thank you very much. Thank you all.
Thank you.
Bye.
Okay. Now we're going back to, we're recessing the planning
Changing your
board.
hat. Changing your hat.
I'm sorry?
You're changing your hats.
I'm changing my hat, yes. And we're now going to handle the zoning board of review matter, which is the application that's been filed by Marcus Early of 08 Rod Way, requesting an extension of the zoning board of review decision recorded on May 8th, 2019, and pursuant to the zoning ordinance, the variance expired 1 year from the date of the decision because the applicant did not commence construction within the allowable time frame. I had requested that that we get a legal opinion from our town solicitor because the grounds were set forth in Mr. Early's letter, but I noted that the request for an extension was not taken within the time period in which he was allowed to take an extension. And I wasn't sure if that would prohibit us or deprive us of the power to grant an extension because it wasn't requested within the time frame of the original granting of relief. So Travis, do you have an opinion on whether this is time barred or whether we can grant the extension?
I do have an opinion, and it does. Oh my gosh, my computer is driving me nuts right now. I apologize. Are you guys hearing the beeping noise coming from my computer?
No.
Okay, good. Great then. Okay. It will not bar you from granting this. In fact, Article 15, Section 5 of Tiverton Code, it talks a little bit about there being a 1 year for the variance and it needing to vest within that year, but then it talks, and I'm going to quote, the board may, upon application thereof, for cause shown and without a public hearing, grant an extension, provided that not more than one such extension for a period of 6 months be granted. So essentially what that says is you have the discretion to give a 6-month extension. And it doesn't say anything about when it's filed, whether it's filed within the initial vesting period or immediately thereout. I think that you guys can probably use your discretion on how close it is from the time that the time period ended to when he filed, which was very close in this situation. But it's certainly within your discretion.
Okay, Mr. Early, you've set out a number of reasons why you need the extension, including a death in your family, a time it took. I know that the application was originally filed by the previous owner of the property, and it took time for you to close on the property, and then COVID.
Hey, Lisa,
Yes.
does Mr. Early need to be sworn in?
I don't think so. I think it's simply a request for an extension. I mean, I don't know. I'll ask Mr. DeCosta.
We'll swear you in. Why not?
I trusted you.
Mr. Early, can you raise your right hand? Let me know when you've done so, because I can't see you.
Can I do what?
Can you raise your right hand, sir?
Oh, yes.
You have to let me know. I can't see you. Have you done it?
Yes,
Oh,
I'm
can see
sorry. I
you.
did
There you
raise
go.
my
Okay.
hand. My hand.
Mr. Early, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Great. You may speak.
Okay. Yes. Well, basically, we did all this work to get the variance before we closed on the property because since the property is basically landlocked, we did all of that and got the variance and closed on the property June 11th of last year. And when I received the hard copy of the zoning variance approval in the mail from Jody Roy, I didn't realize it now until a couple of months ago, but it wasn't even complete. It only had 6 of the 8 pages, so I didn't even see the last 2 pages with everyone's initials and the signature and all that stuff. But anyway, yes. So there was my mother-in-law fell and broke her hip. And that there wasn't a death in the family, but that took time because my wife had to go back and forth to New Jersey, and then we were working on the design of a house and that, and then COVID-19 happened. So I mean, technically, yes, it's my fault that construction did not commence, and it's because of all those various things, as well as working through all of this as well. I simply dropped the ball and I let it expire without beginning construction of that work. So that's why when I realized that, I felt really
stupid. And I'm not a professional builder. I'm just a guy who really likes that land and is going to build a single family home there and get out of Barrington. And I just want to move forward so that we can get the paper street, the unimproved road work done, and then we can continue with our planning and the construction of the house project.
Well,
So
you sound like you had good enough reasons to need the extension, and you don't need to self-flagellate in order to get a favorable relief from us. You don't have to
no,
blame
that's okay.
yourself.
That's okay. Trust me, I beat myself up plenty for this because, you know, I had to fork out the $416.98 to do all the advertising and stuff. Whereas in, you know, that's, you know, a waste of money in my opinion, but I had to do what I had to do. So that's why I'm back here in front of you, and hopefully everything makes sense. There's 0 changes. It's just the only thing that has changed is the elapsement of time. And that's definitely on me, and I do apologize that happened. One thing I'd like to know is I never had a complete understanding of what exactly needs to commence within the period of the variance. Does that mean I have to apply for the permit and have that in hand, or actually begin, you know, actual physical work within the period of time that the extension will be granted, which
Bill or
sounds
Trav-
like is going to be
Which
6
Bill or
months.
Travis, do you have an opinion on that?
Well, the particular ordinance says that you have to exercise the permission granted. And so it says exercise the permission granted or receives a building permit to do so and commences construction and diligently prosecutes the construction. So it's a little subjective, but we can certainly argue to and against that. But you certainly getting a permit and starting your construction is a good step.
Bill, do you have any practical advice for Mr. Early about what he needs to do?
I do believe part of this is constructing a roadway too. Is that true?
That's the whole. Yes, that's the
Yes.
whole. That's the whole point.
So,
is that the South Weedamoo lot, you know, where the cars park, you know, it's the only way in to get to lot 104. So what
Right.
we need to do is have a proper T turnaround, as documented by Civil Engineering Concepts by Bill Smith, who made the presentation last year when we were there in person. And like I said, nothing has changed. So what our plan is to within the period of time that the extension
I got you.
is good for is to begin that little T driveway extension, and then there might not be much work done up on the actual lot, but then we would have the driveway, you know, up to the property line from the entering the Weedamoo lot, the little T-shape turnaround, so that a fire truck can come in there and turn around, and vehicles can get in there easily. That have that ground broken, you know, permit applied for and ground
Okay,
broken.
I understand. I understand.
within the period.
Basically, if you start that process and put that road in, then you're in. Okay?
Okay,
So that's
Okay.
what you have to do.
that's good. That's
Does
great.
anyone have any questions of Mr. Early? Dave?
Mr. Early, could you tell me when the variance expired? I think you were saying June.
No, I believe, see, according to the paperwork I have, that it was granted on the last page, which I never had until a couple of months ago. It says it was granted on the third
May
day of
3rd.
May 3rd, 2019, and like closed on the property on June 11th, 2019. So in my mind, I was always thinking of the closing date, and I just didn't pay much attention to the paperwork of the zoning, and because of all that other stuff happened in life.
So 3 May. 2019, right? Or 20?
That's when it expired.
Yes.
Yeah, that's right. May, right. I guess, and I thought I heard a date of May 8th because it was approved on May 3rd according to the paperwork, but someone, I don't know if it was in emails with Julie, said it expired on May 8th, but that's sort of academic at this point. But I mean, and it was about, maybe 3 weeks after that May 3rd or 8th of this year that I realized that I was an idiot and didn't do anything in time. And then that's when I started my email dialogue with Julie to say, oh, gee, I'm really sorry. I need to get an extension, please. How do I do that? And here we are.
Okay, thank you. You answered my question.
Anybody else?
Okay.
George?
You did fine, sir. Great job. Good presentation.
Thank you.
All right, are we prepared to close the hearing and go into our deliberations?
Yeah.
Okay, the hearing's closed. Does anybody have a problem granting this?
No.
I think
No.
this is, if anybody disagrees, express your feelings. I think this is, we're only talking a few months and certainly good reasons to extend it.
I'll make a motion to extend.
Okay, I'll second it. All those in favor? Voting affirmative, David, myself, Wendy, George, and Jay. So it is unanimously granted, and stop beating yourself up over it, okay?
Okay.
Okay.
Yes. Can you hear me? Because my screen just went blank.
Yes,
Screen went to
we can
sleep.
still see you and hear you.
Here we go. It just came back. So I just wanted to say thank you. And then, so is it for 6 months? And is that 6 months from like today or tomorrow? And also, do I receive any sort of letter from you or like the same exact, decision, like reissued with new dates? How does that work?
I have a question before we answer that. Do we have the ability to extend it for more than 6 months?
No.
No. I mean, they're talking about this coming back in the fall. You might not even be able to get contractors to build this thing if the fall comes back in a nasty way. I just feel I don't want to, if we could extend it.
But all he has to do is vest, right? And that's just an action that's taken, and then it's vested. That's it. So it's
So if he does the road, he's all set. He doesn't have to come back if he start with the road.
once he gets vested, he's good.
All right, man, go do it. All right, thank you. I'm all set.
What do you mean by
question,
vested?
So what Bill responded to you on what you needed to do when he said you're in those things, right? That's being vested. So your variance was for 1 year. Within that 1 year time period, you had to take the actions to actually make it a vested interest, something you could actually act on in perpetuity. So all you have to do is get it vested, which is what Bill had already mentioned what to do. And to answer your question, I think it would be appropriate that the extension would go probably from May 8th. And the only reason why it's going to go back, I mean, I would think back to May 8th, you're here. It's usually not an applicant coming after the deadline is over, right? I don't know. I think it's probably within the board's discretion, but.
Well, I think it should be 6 months from the day that we issue our opinion, which is today.
Okay.
I go for that.
Yeah, I mean, we weren't even open for him to come in to do it, make application to extend.
If we have the power to do it from today, I would say let's do it from today.
Yeah, okay,
Today, please.
Yeah,
That's
That's
my
it.
vote.
okay. We've
Thank
all
you.
voted, right? We're all in on
Yes.
6 months from today.
yes.
Okay, thank you.
Great.
That matter.
Okay.
See ya.
Thank you. So I got one other question. Am I going to receive a new copy of my variance? Like a new paperwork copy?
I think you just get a letter saying that your extension is granted. Am I
Yeah,
wrong?
Okay.
And go
That's
see
just-
Bill in the office.
Yeah,
Okay.
Go see Bill in
That's
the
fine.
office.
Okay. And also, you guys need to learn how to spell Weedamoo.
Okay,
It's WEETAMOO. All of your paperwork ends with MOE. So it's not part of the Three Stooges. It's Weedamoo. It's a Native American name. So
we consider ourselves chastised.
Thank you.
Thank you.
okay.
We
Thank
bad.
you. So
Yeah.
Okay, Andrew, do your job.
Okay.
thank
You're
you.
all set.
Have
Bye.
Stay safe. Bye.
Okay, I should say for the record that there were two other matters
Thank you, Andrew.
that was on today. There was an application for a special use permit filed by BLF Properties. And I don't know if I need to read the whole thing into the record, but that matter was continued at my request because I knew there was going to be witnesses appearing, and I just was very uncomfortable with the Zoom thing because I couldn't get my computer to work, and I'm at town hall using their computer. So I didn't think that would be fair to to the number of people that were going to be coming. And as far as the last matter that was scheduled, an Inland Fuel Terminals, Inc., the petitioner had requested a continuance from with our legal counsel. And given the fact that I thought this is also going to be a rather well-attended and controversial matter, that it would be better served if we can do it live at a hearing in a safe venue, that would be preferable to doing Zoom, which makes me break out in hives. So those matters are continued to our September meeting. I think it's September 3rd. And the 3rd?
Second.
I'm sorry, September 2nd is our date. I think in all likelihood, we are trying to get a date where we can use the high school auditorium or some venue that would be large enough to accommodate people safely. I suggested the ball field, but any place that we can, that's safe for all of us to participate. That's still being negotiated. So that may be set not on the 2nd of September, but sometime later in the month of September for a special meeting. With that, I think we just have administrative matters to review the minutes of February 5th. I was not present for that meeting. That was a matter that was handled by Dave Collins presiding. So I'm not going to vote on the approval of the minutes, but have you guys had a chance to review the minutes? And anybody have any problem?
Wendy?
I didn't see anything that needed any changes. Certainly feel free to jump in if anybody noticed anything I missed.
I make a motion to accept the minutes from February's meeting.
I second the motion.
Okay, and all those in favor?
I think I can vote, right? Yeah, I was there.
Yes, Jennifer, Jay, George, Wendy, and Dave voting in the affirmative. So I guess, anybody want to bring anything up? Any new business that we need to discuss?
Lisa, under administrative matters, it says discuss amendments to zoning board of review rules of procedure and amendments to applications for zoning relief. Can we all just agree that we will table those for another meeting?
Yes, I honestly, we had couple of meetings. We were getting someplace, but when when COVID hit, it just became too difficult to meet, and
Yeah.
So we sort of dropped the ball. I don't know. I think this has been a really hard time for everybody. Those of you who are still working, I don't know how you're doing it, because I can't concentrate on anything.
Let's do that through motion.
Okay. Wendy, you gonna
Officially,
move?
I'll make a motion that we table discussing any amendments to the zoning board of review rules of procedure and amendments to applications for zoning relief.
I second the motion.
George, second. All those in favor? Unanimous. All of us. So is there anything else we need to address?
Don't think so.
Thank you for short relief, Travis.
I'm the
Appreciate it.
closer. What do you
Yeah,
mean?
thanks,
Thank you, Andrew.
Travis.
Thank you, Andrew.
Thank you, Andrew.
Travis, did you go to LaSalle Academy?
We went to high school together, yes.
I was just texting with my sister. I'm like, man, he's familiar.
Yeah,
I have a very stupid question. Someone's gonna tell me who's K, is it? K-A-L, all the way down left?
I have no idea.
Is she just,
Did
Maybe
you guys
it's
make
just
a motion to adjourn?
Party.
Yes.
who is she? Oh, invited
any-
to the party? Okay.
Yeah.
Thank you.
Did someone make a motion to adjourn? I don't hear.
I'm listening.
Okay.
I
Somebody.
make a motion to adjourn.
Second.
I make a motion to
Second.
adjourn.
I'll second.
Okay. Bye-bye.
See you guys.
Bye.
Thank you.
Bye.